A divided U.S. Supreme Court ruled Wednesday that AT&T Mobility can enforce a cell phone contract arbitration provision that requires customers to arbitrate their disputes individually instead of filing class action lawsuits. The 5-4 ruling, which fell along the court's ideological divide, blocked a class action lawsuit alleging that AT&T Incorporated wireless subsidiary acted fraudulently by charging sales tax on cell phones that it advertised as free. And this case was considered a test of the enforceability of arbitration agreements that bar individuals from pooling their claims together in a class action. My guest is Adam Klein. He's partner at Outten Golden in New York. He is the chair of the firm's class action practice group. Adam, welcome back.
Yes, hi. Thank you.
This isn't particularly good news for consumer advocates. What actually happened here?
I agree with that. What the Supreme Court did was take away the right to recover money damages in cases where there's a modest amount at stake at the individual level, but in the aggregate, quite a valuable claim. In this case in particular, the plaintiff, Concepcion, has an economic claim for $30. No one in their right mind would prosecute a case over $30. The cost and delay and there's just no basic good reason why anyone would think to do that. So the only way that claim could be viable is if you could aggregate it and bring it as a class action, which is precisely what the plaintiffs tried to do. The Supreme Court found that because of an arbitration agreement and explicit class waiver provision, that the case could not be brought as a class action, holding that basically state law there, in this case California state law, that would prohibit AT&T from essentially getting away scot-free was deemed to be preempted by the federal FAA, the Federal Arbitration Act.
Okay. Justice Breyer said specifically in his dissent, he goes, what lawyer would go ahead and and take on a case over $30? And that seems to make sense for everybody here, but they're ruling this on federal law.
That's true. And Scalia, the majority in particular, are taking a very peculiar view of the law. They're basically saying you cannot force, in this case, AT&T into class arbitration because AT&T didn't assent to it, didn't agree to it, but at the same time saying that anybody wants to pursue a remedy must file a claim in arbitration. The two in combination lead to the result that no case will ever get filed when you have a small value claim, but it happens to a large number of people. It essentially creates an exculpatory clause, in effect, prohibiting the effective prosecution of the case. That reality is not something that the majority seems to want to address directly and sidestepped it in the decision.
Okay, mandatory arbitration clauses are used routinely in the cell phone contracts and credit cards and insurance and other things, and they can also be used in employment contracts. How does this ruling affect those types of situations?
Well, you're exactly right. The fact is class arbitration waivers in particular are used to avoid the consequences of illegality. And here AT&T is getting away with what they did because of the application of an arbitration agreement and class waiver. That will likely be the case in other contexts, in consumer cases like this one, but perhaps in employment. I think what is obvious is that Congress needs to take action. The result here is intolerable. It leads to the conclusion that an employer or company can violate the law, but so long as, A, it's a relatively small value claim at the individual level, and B, they have a class waiver provision and arbitration provision, that they can essentially get away scot-free. That is not the right result, and Congress should take action.
Talk about our arbitration in general. Consumer advocates obviously are not big fans of that, but they say for a couple of reasons. One, it's unfair, but it's not really transparent like a court case. Can you explain that?
Right. Well, arbitration is supposed to be a less formal process and not subject to court review and appellate review. It really is a device that was supposed to reduce transaction costs and essentially be a substitute for the court procedures that we're familiar with. However, the reality is, because of arbitration agreements, many cases have wound up in class arbitration, and there, the arbitrators are essentially replicating, sort of creating a dual court system and providing the same kinds of discovery rights and due process rights that you would see in court, meaning that in a class action arbitration, there really isn't much difference between that procedure and what you would see in court until now. I mean, until the majority in the Concepcion case held that, as a practical matter, there will be no more class arbitrations.
All right, Adam. Well, we appreciate your time. How do you proceed now in cases like this in the future?
I think we're likely to see congressional action in response to this decision. There are plenty of other examples where Supreme Court comes out with a decision, highly politicized, a 5-4 split, and Congress takes action. The most recent example would be the Lilly-Ledbetter Act that effectively overturned the Ledbetter v. Goodyear decision. There are other examples as well. I suspect that this will really be a rallying call to try to overturn it legislatively.
All right, thanks, Adam.
Great, thank you.
My guest has been Adam Klein. He is a partner at Outten Golden, LLP in New York City. He is the chair of the firm's Class Action Practice Group. You are watching the Legal Broadcast Network.